Hi friends, now we'll discuss about the amendment and seven features on the schedules of the Constitution. The first one, amendments. Yeah, I hope you understand my writing because I shortcut. Try to understand that because there have been 105. There have been 105 amendments, and they all we compare. Okay, sorry. Yeah, there have been 105 amendments till now in 70 years. If you see in US, there have been sorry, 27 amendments in 200 years. There are so many amendments in our constitution, and Parliament amends constitution as future listed in Article. According to Article 66, Parliament can amend the constitution. Okay. Basic amending process. If you see, power allows only. We'll see. We'll write here. Basic amending process. Powers are allowed only with union. State limited role with our state limited law and only MP can introduce. And here it is a bill introduced by the minister, either the government or any bill from private member is termed as private member. If it is by minister, it's government bill. If it is by private member or private member, it's private member. Private member means it includes even the member of ruling party who are not ruling the executive. Or like for example, there are some members who doesn't have any position, but they belongs to ruling party, but they doesn't belongs to the executive. Yeah. Some bills need sanctions from the president before introducing, like you can say permissions or approval or sanction, anything. Some bills need permissions or approval from sanctions from president before introduction, for example, state reorganization, money bill. But there is no permission or approval or sanction is required for constitutional amendment bill because constitutional amendment bill is done under Article 68. Okay? The bills of the constitutional amendment can be introduced in any both the houses, either in Lok Sabha or Rajya Sabha. And for constitutional amendment bill, there is no joint sitting. And that's why this should be passed separately from each other. There's no joint sitting like ordinary bill. This should be passed separately from each other. The bill firstly passed by majority total members of the House, and second, two-thirds of the members present and voting. But both these norms must be followed simultaneously irrespective of any vacancy. Rigidity is reflected means like for any amendment, need provisions like dealing with center-state relation. It has approved by resolution with the simple majority of states. And this can be considered with the three for three simultaneous. But see, what I actually is like, for example, if any amendment bill, constitutional bill, which involves states, then a simple majority of states is required. Simple majority of states, which is approved resolution. Okay. And the next one, provisions that require approval by states include election of president, extent of executive power between Union States, provisions relating to Supreme Court and High Court, distribution of legislative powers between state Union States, and any alteration schedule 7. Okay. Next one is basic amending process. There can be questions asked from amending. We have no idea what we will see. Powers only with union. State have a limited role. MP can introduce. Okay. Just quickly. If administrative is government bill, if private member is private member bill. Private member government ruling party can fit, but they are not in the executive. Okay. No provisions for joint sitting. And no, actually, some bills need sanctions or approval from president before introduction, like state reorganization bill, money bill. Okay. And no permission required for constitution amendment bill, and there is no joint sitting. Okay, it needs to be passed separately from each house. Okay, and the bill has to pass by a majority of total members of the house and neither two-thirds. Okay, and if any rigidity, which if there is an amendment needed, uh, provisions dealing with the center and the states, simple majority is required. Approval resolution from all the states. A simple majority is required. Approved by a resolution from all the states. And provisions which include approval by the states, like election of president, executive powers between center and state, okay, provision related to Supreme Court, distribution of legislative powers. And basic features. So this is basic amendments. And basic feature is bulky. We have seen areas 450, 25, and 450 articles, 25 schedules. 12 schedules, could say partial 12 schedules. 12 schedules and 25. Next thing is borrowed constitution. They have borrowed from all the countries, almost all the countries in the world, like the top of US, UK, Russia, France, Germany, Australia, Canada, South Africa. Okay, so and that one is more less rigid, more flexible, and balance distribution of powers among three organs like executive, legislative, and judiciary. And federal is up to unitary balance. Westminster should have followed with the elected head of the state, judicial, non-judicial rights. The emergency provisions, Article 352, 356, 360. Emergency provisions, President rules of financial emergency, financial emergency, President rule. Independent judiciary, federal system with federal setup with the unitary basis, justiciable and non-justiciable rights, emergency provisions, independent judiciary, universal adult franchise, and schedule of the constitution, which is some schedules, total 12 schedules. First one states about union, sorry, list of states and union territories. It is Article 1 to 4. First schedule talks about the list of states and union territories. This talks about Article 1 to 4. And second, contains salaries, emoluments of salaries, emoluments of important constitutional dignitaries, like president and vice president. Okay. Third one, first is list of states. Second one, salaries, emoluments of important constitutional dignitaries. Third one, declares with oath. Since the nature and the duties responsibility of dignitaries differ from each other, the president, governor are similar. The PM, CM, council of ministers, their responsibilities and the dignity differ from each other. So their oath differs. Oath signifies a commitment and a general specific direction to implement an institute act. There has been tendency, there has been issue of respect with to taking oath in the name of God due to the tendency to replace God with personalities or individuals. A minister take oath both oath of office and oath of secrecy due to being a part of government. The second ARC headed by Veerapalla Moli. Veerappa, he recommended that second ARC oath of secrecy should be replaced by the oath of transparency. Oath are just means like he said the second ARC headed by Veerappa Moli recommended oath of secrecy should be replaced by oath of transparency, owing to change demands and relationship of the citizens with the government. And the next point to form of oath and affirmation to be made by candidate for election of president. Oath and affirmation to be made by candidate for election of president. These are some like president, vice president, chief justice. Okay. Schedule 4. So till now, I have seen first list of states and union territories. Second one is M1s, salaries, third one is fourth. Okay. For the fourth one, bill support or deals allocation of Rajya Sabha seats in states and UTs. Okay, allocation of Rajya Sabha seats in states and UTs. In US, the upper house called Senate. In Senate, they have total 100 members and 50 members from the state, having two members from each. This representation is equal irrespective of the size of population because there are some states which are high in population. There are some states which is very low in population. A well-developed high city from two and a least developed city two. This is equal irrespective of the size of population. And this representation is of India is unequal because in India it depends upon the population. Here it is size. Here depends upon the population. Okay. And schedule 5. Administration and control of schedule areas and schedule types. Schedule 5. Administration and control of schedule areas and schedule types. 6. Administration of tribal areas in Assam, Meghalaya, Tripura, Mizoram. Administration of tribal areas of Assam, Meghalaya, Tripura, Mizoram. Schedule 7. Legislative distribution between center and states. It means has three lists, namely union, state, concurrent. Earlier, the union has 97 subjects, which has been enlarged to 100. State had 66, now reduced to 61. Concurrent has 47 subjects, now increased to 52. Alright. Schedule 7 deals with legislative distribution between union and states. It has many three lists: union, state, concurrent. Earlier it has 97, now it has 101, also 100. Earlier it has 66, now it reduced to 61. Earlier it has 47, now increased to 52. Yeah. The 5 subjects have been subtracted from the state list and have been added to concurrent list. Why? These 5 subjects are shifted and added to concurrent list. Why? And also those subjects which need national uniformity, not statewide. The national uniformity is either desirable or is not essential. What is well, concurrency actually, if any subject is placed in concurrent list, both center and state has right equal right. If any subject is placed in state list, center doesn't have any right. So five subjects have been shifted from here and placed in function list because it is a national uniformity, and also states should have equal responsibility in making corrections in the subject. But the concurrent list is both union and state can make us and subject to uniformity made desirable but not essential. Well, those subjects with national uniformity is neither desirable nor essential. Okay. And what is required is local adoption of law. To diversity among states is placed in the state list. After GST Act, there's 101, 101 First Amendment 2016 Act. Two subjects, namely 92, 92C, were removed from union list. Sorry, were removed from union. And subjects were 52 and 55 removed from state list and resulted having 160 Schedule 8. Recognize Indian languages. There are officially there are 22 languages. Now, if you see some depth, English is not mentioned in these languages. Originally, it has only 14 languages, now expanded to 22. Okay. The most of the languages are associated with the state, example, Tamil being Tamil Nadu, and some languages do not have linguistic or organized separation, namely Bodo, Dongri, Konkani, Nepali, Sanskriti. So they don't have any state, but there are some languages which are associated with organized separation, like Tamil, Tamil Nadu, Telugu, Telangana. Dictators of the schedule have mentioned using specifying tool for various demands regarding the linguistic based demand, like Bodo coming. There have been 38 instances of demand of language to be included in schedule like Kasi, Pahadi. Okay. The benefits can be derived from Article 344 and Article 351. The caste duty of the government to develop Hindi language. In order to develop Hindi language, government can borrow languages mentioned in literature, primarily Sanskrit. Article 351 specially mentions about the development of Hindi language. It shall be the duty to promote, spread Hindi language. To develop it may serve as medium of expression for all the elements of composite culture of India to secure enrichment and assimilation without interfering with genius. Yeah. The classical language status have been conferred only some language, namely Tamil, Sanskrit, Telugu, and Kannada. And if you see, it is added by PM Nehru through First Amendment and will deal with fundamental rights section. Fundamental rights section will be and schedule to this anti-defection law. Why a anti-defection law is required in schedules? Because breach of trust. Once they get elected or once they get nominated, they are leaving the party. The breach of trust and instability, political corruption, political parties. These are some factors. And provisions of trust schedule is resignation from political party leads to seat vacant. And this provision was present in original law that along with the defectors, if one-third split, it would demand a legislative bill. Defying a party whip is not condemnable in 15 days, and independence then. For example, if a non-member, if a person who is nominated already as a member of party, then if he defects, if a person nominated by a member of party, nominated by a member of party, if he defects, then he can join a party within 6 months from date of nomination. Post 6 months, if he joins a political party, anti-defection law comes into play. He can join any party within 6 months. Okay. Post 6 months, if it is independent member, if they join any political party, if they join a party, and the challenges with the anti-defection law because the power lies with speaker. Speaker himself undergo defection because he has to leave his position and go to speaker position. So speaker himself will goes to defection. The petition is to be filed with secrecy general laws. Okay, and this is regarding ADL petition. And if ADL petition against speaker would be taken such a person, power lies with speaker. If you submit under the anti-defection law on speaker, it will go to speaker. Speaker usually hold the membership of of the political party. Any decision made by him can be seen with double lens, doubtful lens regarding the all the fairness. In Hito one Hito Holland case, it says that there is no wrong in the case being decided by the speaker, but there will be provisions for judicial review. The speaker can act as quasi-judicial capacity, exercising judicial functions. Anti-defamation law, this is a, we'll see a quick recap. We'll see a quick recap of amendment and election official. First one, amendment. Okay. Basic basic amendment process according to Article 368. Listen carefully. Also, we will this is a quick recap. Basic amendment of the Constitution. The first one, basic amendment process according to Article 368. Only Union Parliament can initiate the bill to amend. Okay, then no state can involve. Only Union or Parliament can do this. It can be introduced either any house. No they for see for few bills such as state reorganization or manager. It requires president sanctions before introduction, but otherwise there is no presidential sanction required for ordinary or constitutional amendment. It should be introduced only in union, which is parliament, and it can be introduced in either of the house. Third one, ministers who are not in who are not in the executive or private member bill, or ministers who are part of the government as full government. Okay, and voting will be majority of total members of each house and two-third presented voting. And there's no joint sitting for there's no joint sitting. Each should be each house. We are talking about constitutional amendment, and there's no joint sitting like order. Presidential role: the president must give assent once the bill is passed. He must give assent. Okay. Now, role of state. State plays a role in matter affecting international relationship like GST, Schedule 7. Under Schedule 7, Union list, state list, concurrent list, Supreme Court, High Court jurisdiction, and the president election. Here, the state can play a role in matter affecting international relationship. And comparative perspective, India, 105 amendments in 75 years, whereas US, 27 amendments in 200 years. This is basic amending process. Okay. Let's do. Amendment of the Constitution first should be introduced in Parliament. It can be introduced in either house. Result sanction is not required before reduction. And to yes, majority is required. And majority is required and to the majority. And there's no joint sitting. Okay. And president after the bill is passed, president is required. Okay. And the role of states, the states will perform GST, Supreme Court High Court jurisdiction, president election. If we compare, India did 105 appointments in 70 years. US 27 years, 27 appointments in 200 years. Current features: balance of power. India follows a via media between UK and USA. India follows middle path. The judiciary empowered judicial review, but Parliament retains amending powers. Parliament has amending power of the constitution. Whereas judiciary has judicial review, or it can take the case about the amending procedure. Okay. Political injustice, like equality before law, universal and substantial equality. And central federal setup with unitary powers, Westminster system elected to state, head of state, judicial and non-judicial rights, and independent judiciary, universal franchise, secular, secular. Again, these are some silent features. You see, separation, balance of power. The silent features of balance of power. In the follows middle way, universal franchise, secular, and federal with center, federal tilted towards center. Westminster system, like elected to the states and justiciable and non-justiciable rights, independent judiciary. Third one is amendment and seven features of schedule of the constitution. Schedule one, list of states and duty. Two, salaries and emoluments in both. Four, draft of seats, right? And fifth, administration of control of schedule areas and schedule types. Six, AMM, the Assam, Mizoram, Meghalaya, Tripura. And seventh, deals with legislative provisions, union, state, concurrent. Kunchi recommended some subjects education back to state list. Other some list really was 66 back to 61. Five has been shifted to conference list. Um, okay. So currently union has 100 list. State has 66, 61 list. This is something 62, 50, so 62. Okay. 9th and 10th. Original constitution has only 8 schedules. If you see, but now the present 12 schedules are supplementary addition. Original has only 8 schedules. So ninth, First Amendment Act 1957, 10th, 52nd Amendment Act 1985, 11th, 73rd, 12th, 74. So his main ninth Amendment Act, ninth schedule was added by First Amendment Act. Okay, ninth schedule added by First Constitutional Amendment Act 1951 of the Jawaharlal Nehru government. Okay, and purpose is to protect the laws from judicial review. Judicial review is a protect laws, especially the land reforms and agricultural laws. Facing another schedule and judicial interpretation, originally Union from judicial review. Okay, intent is simple to identification law. Present added by 52nd Constitutional Amendment Act of 1985 during Rajiv Gandhi government and linked with Article 102 Clause 2 and 109 191 Clause 2. Yeah, it applies to members of the Parliament and state legislature. Not applicable to Panchayati and urban local bodies. Yes, members of the Parliament and state and union Parliament. Not applicable to Panchayati and local bodies. Rationally, I say actually, what is the rationale with respect to identifying clause, breach of trust, political corruptions, and instability and party investment. Okay. Schedules of the Constitution, if you say schedules of the Constitution, the key provisions of 10th schedule is ground of disqualification is voluntary giving of the party membership. Voluntary giving of party membership, defining the party fee. Let's like if the party with 15 days, voluntary giving of the party membership. The independent members, they are disqualified if they join a party after elections. Independent members, they get elected after elections. If they join any political party, they are disqualified. Okay, and if nominated members, if they join any political party within 6 months of nomination, they can join nominated members. They can join any party within 6 months. If they join any party after 6 months, then they are subject to disqualification. Except the speaker, deputy speaker, chairman, deputy chairman of Lok Sabha. Vice President not so covered under member rules. An amendment to an identification of 91st amendment is removed one-third of split vote. Allowed merger if two-third members are dissented and condemned separate. Okay. Next, we will discuss about territory of India and the organization of states.